Hi, everyone. Harry here with a weekend YouTube, a rare event, but I really wanted to explain to you one of the most squirrely and I think disingenuous documents I've ever seen anywhere in litigation at any level. And it's filed by, yes, indeed, the administration and, yes, indeed, the James Comey prosecution. All right, remember where we were on Wednesday after the hearing, the gobsmacking moment. It was that on really pressed and summoned to the podium by Nachmanoff, Halligan had conceded that the grand jury had actually never seen the indictment in the case. The indictment in the case states 2 counts. And that's because, at least from how Halligan and the foreperson have represented it, they first had a 3-count indictment. The grand jury turned down the first. And then rather than doing what the rules require and anyone would, and I mean anyone, I've never heard of what happened here next. Rather than going back to the grand jury, good morning again, ladies and gentlemen. Here's the court reporter. We're handing you now, we got your decision, and now we're handing you a different indictment with just those 2 counts. Please confer and vote. They just went ahead with the 3-count indictment, 1 thumbs up, 1 thumbs down, and 2 thumbs up. And as Halligan was forced to concede, tore off count 1 and renumbered counts 2 and 3 and had her sign it and served it up to the judge as the indictment in the case. And indeed, it is the indictment in the file. It's the operative piece of paper. And so on Wednesday, Comey's lawyer was very quick to stand up and say, there's no indictment in the case. The piece of paper here hasn't been given to the grand jury. And that was flabbergasting. That was, Nachmanoff sort of grimaced for a few seconds and pursed his lips and dismissed Halligan. And it was a mess. It was, as I said in my Substack, she'd had egg on her face before. This was the entire omelet. But okay, that's the state of things. And they'd finally, established it had taken a while even to get that much out of them. That's where things stood on Wednesday. Then we have on Thursday, the next day, this motion filed. And notice it says correction of the record. Let me just say, you're the prosecutor. You're the Department of Justice. You find out this big brouhaha when you gave them this information. You misinform them. It's like a colossal headache and crisis. Holy cow. All right, if we're going to have to correct the record, man, we better be 1,000% every comma is accurate. It's really embarrassing. You are falling on your sword, but if you have to do it, you have to do it. And what they apparently were trying to say, when you look at this short document, it says, flat out, they give they cite an exchange between the court when the indictment was handed up, the clean 2-page one, and the foreperson, which said, so you voted on the one that has the 2 counts. That's the court, obviously. The one that has the 2 counts is the one that's in the file, not the one with 3 counts. And the foreperson, yes. The sworn testimony alone establishes, this is what the United States is presenting, finally coming completely clear on the record, that the grand jury voted on the 2-count indictment. Head spinning that this gobsmacking confession turned out to be, never mind, had even that part wrong, but if what she had was inaccurate, you sure better make sure to correct the record right away and have everything 100% straight. But it turns out, as you look at the other 2 pages, that's not what they're doing. It's really stunning to me. It's not a notice correcting the record. It's a attempt to re-argue the record and reconfigure it and take what we already knew, and the punchline being the grand jury never passed on this actual operative indictment, and obfuscate it or even imply the opposite. Right on the first page, the sworn testimony alone establishes that the grand jury voted on the 2-count indictment. That's the United States saying, no doubts, Judge Nachmanoff. I know we were a little confused on Wednesday, but now we know the grand jury voted. Except it's a total, bogus attempt to pull the wool over his eyes. And if you go forward, you can't believe it under the context, even with this Department of Justice, but it comes clear. Okay. So the next thing they talk about is, the foreperson who's pretty confused saying, well, the 3 counts, it should be just 1 count. Should it be 2? And so that was very confusing. But it was the very first count we did not agree on. And the count 2 and 3 were then put in a different package, which we agreed on. Okay, so basically saying again is the foreperson, we somehow in the grand jury room made a different package and we agreed on it. Or what would have happened, the U.S. attorney would have made a separate package. And they did. That's what Halligan testified. AUSA made a different package, said sign here, etc. But it's total deceptive crap, I think, because the court then says in this motion, I'm a little confused as to why I was handed same 2 things with the same number that are inconsistent, and it seems crazy, but okay. Then we go to, I assume I'm going to file both of these now that it's presented in open court. I just want to make sure that you understand, and that was your intention. Halligan, okay, understood. This confirms the court's recognition that the 2-count true bill, and here's what we're supposed to hear on the facts, that the 2-count true bill was presented to the grand jury for sure. That's not what the sentence says, though. This confirms the court's recognition that the 2-count true bill is the valid operative indictment, meaning they're not making the factual representation that it was passed on. They're making the legal argument that it's the valid operative indictment. But that's the whole frigging point. Is the one that's so fine. The whole friggin' point really is, did the grand jury vote independently on that valid operative indictment, the one that's now in the file, the one that on Wednesday, when Halligan made her concession in court, Comey's lawyer jumped up and said, well, there's no indictment in the case, another reason to dismiss. And in fact, they have now come in with a motion saying exactly that and asserting there's no motion, there's no indictment in the case, meaning the grand jury didn't pass on it. But referring to this as ambiguous and confusing, which it is at best, what really happened. As we know in their final, look at what they say finally. The transcript leaves no room for ambiguity. The foreperson confirmed the vote, meaning the somewhat confused non-lawyer foreperson tells the court, we voted on 2 and 3. The court acknowledged the vote, meaning nothing, meaning the court heard what the foreperson was saying. The court docketed the 2-count true bill as the operative indictment, having heard what the grand jury said. Only count 1 lacked concurrence. Right? Counts 2 and 3 were true billed by at least 12 jurors. So that's the end of their big, all of this is established clearly. And what they, I think, have to be saying is that they true billed it in their first and only vote when they said no, yes, yes. And that is exactly not what the point is. And it's an incredibly obfuscatory document trying to just sort of throw sand in the eyes. But this is going to be really clear to Nachmanoff. And just to cut to the chase, this is now not so much about did they or didn't they vote on it. I think it's going to be pretty clear that they didn't vote on that operative indictment. Comey is right. Comey's motion is well taken. But it might be under the law, the case that was presented to the parties in open court, that's not a reason to dismiss without prejudice. But this is now about the competence and credibility of the Department of Justice and Lindsey Halligan. And after the mess that had been created on Wednesday, the gobsmacking moment where they fess up, for them to come in with a document like this, clearly designed to distort or obfuscate the truth and say, basically, even if there was only one vote, this is the true operative indictment, simply because the foreperson said so. It's like stunningly dishonest. And at a juncture, you're the United States, you've confused the court, you've kind of irritated the court, and now you come in with this guy. I think Nachmanoff will and should be apoplectic. In the meantime, Comey has now come in with a motion saying the two count indictment, the actual one, the grand jury, in fact, never passed on. So the issue is totally joined, and Nachmanoff is going to have to, resolve it or make findings. And I think he will clearly say, because that's what in fact happened, he'll either call the government on the carpet and say yes or no. Did the grand jury vote on just that 2-count indictment? And take it from there. And he may not dismiss on that basis, but man, oh man, I think, will be really displeased. And I think, he was already trending toward a dismissal in selective prosecution motion and the misstatements that Halligan made in the grand jury. This sure doesn't help. But, he's a good and honest judge. I don't think he should punish them for this. I think he won't, but he'll do those decisions on the merits. But man, just the ugly fact of at this stage of a big time prosecution with all the focus on it, the DOJ comes in and just tries to muddy the waters is really, really shameful. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.